Mayank, tell me something about yourself.
Good evening, sir. My name is Mayank Srivastav. I have done my schooling from City Montessori School, Lucknow. I was born and brought up in Basti. I have done my BLLB from University of Allahabad in 2022, and after that LLM from University of Allahabad in 2022.
Now you are pursuing your LLM.
Sir, I have already completed in 2022.
You have completed your LLM.
Yes, sir.
So, what was your topic in a dissertation?
Sir, my dissertation topic was critical evaluation of Section 498A of IPC in the light of recent guidelines given by the Honorable Supreme Court of India.
And what is the difference of the cruelty, civil cruelty, and a criminal cruelty?
Sir, criminal cruelty is punishable offense under Section 498A of IPC, whereas in civil cruelty, only divorce can be taken as a ground under Hindu Marriage Act Section 13.
So, both are the inclusive or exclusive?
Sir, Sir, both are we can say both can be termed interchangeably. One can also seek divorce and also punish the offender also who uses cruelty against the other spouse.
So, actually, I just want to know, is there any difference between 498A and the grounds which is given in the Marriage Act?
Sir, there is no difference. Section 13 of the Hindu Marriage Act says that cruelty, which is under Section 498, that can be the ground for divorce. So, cruelty, the meaning does not have any difference.
So, both are inclusive?
Yes, sir, both are inclusive.
Okay. So, what is the most favorable subject in which you are more comfortable?
Sir, all subjects are good, but I like to read Indian Evidence Act and Indian Penal Code more.
Okay. Have you heard about the Panchsheel doctrine, which was propounded by the Supreme Court relating to the circumstantial evidence?
Yes, sir, I have heard about the Panchsheel doctrine. It is related to circumstantial evidence. The case law I cannot currently recall, but according to it, circumstantial, there are certain guidelines which were given by the Honorable Supreme Court while dealing with the cases of circumstantial. Sir, five only. Five guidelines given by Honorable Supreme Court while dealing with the cases of circumstantial evidence.
So, what are the guidelines?
Sir, firstly, the Supreme Court said that there has to be a connection between the circumstantial evidence and the transaction which resulted in the offense. Uh, there must be cogent and full and truthful disclosure of facts, and no one. There should be no chance of fabrication or no chance of dispute. It was this only, sir. I can recall. The fact, sir, one more, the fact should be so closely related that there is no chance of fabrication. And it should disclose the guilt of the accused only and no one else.
So, IPC is also your favorite subject.
Yes, sir.
Have you seen any difference in the Bharatiya Nyaya Sanhita, which is introduced in legislature?
Yes, sir.
And the draft of the Macaulay?
Yes, sir. Sir, the first difference that I have seen in the new Bharatiya Nyaya Sanhita is that an offense of snatching has been added. Earlier, there was no offense of snatching. It was counted under the offense of robbery only. Secondly, a major difference has been seen that organized crimes have been made an offense. Earlier, there was no provision for organized crimes. Thirdly, I can recall, sir, mob lynching has been made an punishable offense. earlier mob lynching was not a separate offense.
So what is the need to establish or draft a new IPC, although it is covered by the existing Indian Penal Code? All these offenses are covered. What is the relevancy here?
Sir, the new penal code means the new Nyaya Samhita which has been tabled on the tabled in the parliament. Uh, it has added certain provisions which were not earlier, and to give effect to certain provisions like sedition was very much in news, that there should the parliament should consider the law of sedition, should reconsider and change its provisions. So there is a change provision for law of sedition. So it has made more accessible to courts, and delay and there will be cut down in the delay which is done in the delivery justice system. And
Okay.
sir, one more I can recall is there were many times used the British Crown word, which showed that we are still under the rule of the Britishers. So
This
that is
can
also
also be,
removed.
this can also be repealed by the legislature. What is the need of the new Sanhita? So all these facts, so what you are telling me that it can bring some new change by the amendment.
Sir, this sir, as far as I know, sir, this bill, sir, sir, this bill has been introduced by Indian legislature. The earlier was done by Britishers, so it is our provision, our law, we can say, made by Indians.
Okay, this is the fact. This is the reason behind the new legislation, right?
Yes, sir.
As per your opinion. Okay,
Yes, sir.
just tell me what is the conduct crime?
Sir, I request you to please repeat the question.
What is the conduct crime? Have you heard about the term conduct crime
No, sir, I have not heard about the conduct crime word.
and sequential crime? The crime which is punishable only on the basis of the conduct,
Yes, sir.
just like a criminal
Only.
conspiracy, just like the criminal
Yes.
conspiracy is the conduct crime.
Okay, sir.
Any other offense?
Sir,
Okay.
sir, I cannot remember.
Okay. What is the common intention?
Sir, when two or more persons do some act or omit to do something in furtherance of their common intention, then both will be liable as if the act was done by them alone.
My question is, what is the common intention, not section 34? What
Common
is common
intention.
intention? Yes.
Sir, common intention means the intention of two persons or pre-arranged plan by two persons for committing any act, for doing any act.
And this term is also used in Indian Evidence Act, in which reference?
Sir, Section 10, I can recall, Section 10 of the Indian Evidence Act, acts done by two persons in furtherance of their common design or common intention.
Okay, when we read the section 4, may presume, shall presume, and conclusive proof. The opening line of the definition, whenever it is provided in a may presumption, whenever it is
Yes, sir.
directed in a shall presumption, and whenever it is directed. What does meaning of this? What is the meaning of these terms? Why we are studying like this, and why it is mentioned like this?
Sir, sorry, sir, I cannot say why it is.
Okay. In Indian Evidence Act, the definitions of the evidence is not given. Are you agree with this?
Sir, but it says evidence means and includes.
Means and includes.
Yes, sir.
So it is a very narrow different definitions which is given by the Stephen. Are you agree?
Sir, almost all kinds of evidence are covered by the definition of oral evidence or documentary evidence.
And where is the physical evidence? What is the meaning of the physical evidence? Whether it is a section 3 of the Evidence Act, any gun which is recovered from the possession of
Yes,
the accused,
yes, sir.
whether it is a oral evidence or a documentary evidence, what kind of evidence?
Sir, that is a discovered fact.
Okay, whether it is evidence or not.
Yes, sir, it is evidence. It is evidence.
Under which section? Under which section?
Sir, sir, under section 27, or we can say it is real evidence.
Real evidence is covered under the definition or meaning of the evidence under the section 3 of the Indian Evidence Act or not? That's what I am asking to you.
Sir, it is not covered under because it is neither document nor it is oral evidence.
Simply, if it is not oral evidence or a documentary evidence, then how court allowed to produce before him? On what provision here the court has a power to entertain the such type of things?
Sir, section 136, I think admissibility of evidence, courts consider which evidences are admissible or not. Those are relevant, then they will be
If
made admissible.
according to you, this is not a definite. Here my question is, as per you, this is not evidence. How the court can allow this?
Sir, because it is relevant under sections 5 to 55.
Under what section? It is irrelevant.
Sir, section 27.
Okay. The confession which is regarded by the magistrate under the section 164 of the CRPC is the evidence or not as per the section 3 of the Indian Evidence Act?
Sir, it is oral evidence as per section 3 of the Indian Evidence Act.
No. It's section 3 when you read, then it is written. What is the definition? Can you tell me?
Sir, yes, sir, I can try. Sir,
Okay.
all the statements made before the court
Yes.
during the process of inquiry or trial.
So under the section 164 of the CRPC, the confession which is regarded by the magistrate under the process of the investigation, not inquiry or trial, then because when you read the section 164, it is written there before the commencement of the trial or
Yes, sir.
during the
Yes, sir.
investigation. So
Yes, sir. Sir, I don't know the exact reasoning behind this.
okay. And what is the difference between logical relevancy and legal relevancy?
Sir, legal relevancy may be or may be logically correct, but logical relevancy may not be always correct. whatever is legally relevant is only admitted as evidence.
Give me any illustrations.
Sir, illustration. Sir, statements made during Section 122 privileged communication. It is a logical, but it is not admissible in evidence. But
So,
legally relevant, Section 5 to 55, whatever falls, then that is relevant.
Section 5 of the Indian Evidence Act is known as the backbone of the Indian Evidence Act. Why?
Sir, because it makes the facts admissible, which fall under the sections 6 to 55 of the Indian Evidence Act.
What's it?
Means that it says all facts relating to relevancy, all statements relating to relevancy of facts are admissible as evidence.
Only the relevant fact, not fact and issue.
Sir, fact and issue and relevancy of facts also.
Okay, my last question is, what is the best evidence?
Sir, direct evidence is the best evidence, or we can say oral evidence of the witness or the statement of the accused. It is called the best evidence.
Think again. Oral evidence or a documentary evidence?
Sir, oral evidence.
Thank you, beta. Thank you, sir.
Yeah. Rajgopal? Raj?
Yeah. Yes, Mayank.
Good evening, sir.
Good evening. How are you?
Sir, I'm good.
Achha, tell me what is, you talked about a definition of evidence where you said includes. So what is the significance of this word includes there?
Sir, the word includes means that the definition of the word evidence in is inclusive and not exhaustive.
What does that mean?
Sir, it means that it includes oral evidence only and documentary evidence only.
Only.
Sir, as per the definition, it means.
No, what is the difference between an inclusive definition and an exhaustive definition?
Sir, exhaustive definition leaves room or space for other things also, but inclusive means only those which fall under the category of what is provided.
Are you sure?
Yes, sir, I think so. As far as I know.
Maybe somebody else, a panelist, because I'm not a legal expert. Some panelists can chip in.
Respected sir, it is the other way around, exactly the other way around, sir.
Yeah, Mayank, exhaust मतलब क्या होता है? Exhaust.
Sir, to finish, खत्म करना.
पूरा सब कुछ है उसमें. Include मतलब ये भी है, इसके अलावा और भी है.
Yes, sir, I was wrong.
Yeah. No, you can relax. You don't have to be speaking without thinking. So just think about logically what it should be. Right?
Okay, sir. Okay,
So
sir.
that's where the question on Evidence Act, what you're responding, you're not getting it right because you presumed inclusive means exhaustive actually. Inclusive means apart from this, there can be everything else. This is only indicative. Right?
Okay,
so tell me about what have you studied?
Sir, I have studied evidence and IPC.
Oh, what's your degree? As in which subject have you studied?
Sorry, sir. Sorry, sir. Sir,
Yeah.
I did my BLLB from University of Allahabad. In law subjects, it was IPC, CRPC, evidence, constitution. All subjects were included in my UG program.
Okay. And then PG, you did post-graduation also, is it?
Yes, sir. I did post graduation,
In
but it
which
was my
subject?
sir. Actually, it was general LLM. There is no specification in
Okay.
University of Allahabad.
Okay.
So all law subjects which include tort or general principles of crime,
But that's what you learnt in your
constitutional.
LLB also.
Yes, sir.
So how was it different? The LLB and NLM experience? Did it add value
Sir,
to your knowledge, or it was just refreshing the same knowledge more than once?
no, sir. I got to learn some new things because there was a higher approach, and also I was advised to make a dissertation, which helped me a lot to know what the topic is and how it goes.
That was one semester. So you did 4 semesters, out of which 3 were just a repetition, is it?
Yes, sir.
Peop-
General classes,
Yeah, carry on, carry on.
sir. General classes were held in the online mode, and these subjects were taught by our teachers, respected professors.
But the same thing was taught in your LLB.
Yes, sir. We can say the subjects overlap.
Do you think it was worth doing an LLM? A lot of people criticize the LLM program in Allahabad University, saying that it's just a repetition and it breeds, it's just a means for people to continue to go to college to appear for competitive exams or to do politics. What do you have to say?
No, sir. I would not say that. It helped me to increase my knowledge. Uh, I came to know about many new things during my LLM program. Teachers taught something new.
So would that mean the LLB program, they failed to teach the same thing better? They should have
No,
done it
sir.
better in the LLB program.
No, sir. That was not the case. Both are good at their level.
Okay, something higher level of thought. So tell me
Yes,
about
sir.
one area where your perspective changed after you did your LLM as compared to what was your perspective when you did LLB. Tell me one area of law where your perspective changed apart from the dissertation topic, something else.
Sir, in constitutional law, I think I came to know about new things, many new things when I did my LLM program. Uh,
Tell me one instance in constitutional law that your perspective changed after doing LLM. In constitutional law,
Sir, the
Article
study was
370,
yes,
any
sir.
particular article, any particular area that you developed a better and much better understanding after doing your LLM.
Sir, Article 14, Article 21. I
So what
read
within that,
them.
let's say Article 21, what was the new perspective after doing LLM?
Sir, many new changes were seen. Firstly, in BLLB, I did not read in too much about Article 21, but when my LLM program was going on, I read it very clearly and saw many facets which Article 21 provides. It is actually like blood to our body. Article 21, I can say it is like blood to my body because
Hmm.
it gives everything a person can face in today's scenario. Like there are many examples for it, sir.
Okay. What's your view on Article 142?
Sir, it provides varied powers to Honorable Supreme Court to do complete justice.
Hmm.
Sir, there should be given such power because in case something is not covered under the law or there is inherent misuse of justice, or then Supreme Court can use this power. So I think this is okay.
Is it to be regularly used or is it to be sparingly used?
Sir, as far as I know, it has not been regularly used. It is sparingly only used.
Okay. Sparingly as in once a month, once a month in a judgment or once a couple of years in a judgment?
Sir, whenever there is a gross negligence of justice, or when the ends of justice are not are abused, then
Okay. You should have you read the debate in the Constituent Assembly when this Article 142 was being conceptualized?
no, sir. Constitutional Assembly debates I have not.
Okay. No, any commentary on Article 142 would start with that. You know, they conceptualize this as something which will be used rarely. So you are happy that it's being used rarely, or you believe that it should be used more often?
Sir, it should be used rarely because there are less cases which in which Article 142 has to be invoked.
So doesn't it give a Supreme Court the primacy in the entire governance structure, which is something which a democratic structure of governance should not really have? Yeah, Mayank?
Yes, sir.
Yeah. Did you hear my comment?
Yes, yes, sir.
In
I
a
have heard.
democratic structure of governance, it gives enormous supremacy to the Supreme Court to go beyond a law framed by Parliament. They, of course, have the power of the judgment relating to the basic structure. But despite that power, they have a specific power on every law, where even if it doesn't deal with the basic structure, they can still intervene and read down a section.
Sir, judiciary should act as check and balances if the parliament does some malified act. So, according to me, this gives varied powers to Supreme Court, but Supreme Court has never misused its powers, and it will never. I think it will never do so. It will never impound in the shoes of the executive.
But they have the power to go beyond that, you know. On
Sir,
the Ram Mandir issue, nobody ever made a prayer that an alternative land is to be given to construct a mosque. So when it is not my prayer, why does Supreme Court give me that?
Sir, this is, I think it was to do complete justice. When one party was given the Ram Janmabhoomi, then
No,
the
but I'm
second
not
party
asking
was.
for it. I'm not asking for it in my prayer. So,
Sir,
doesn't it give the Supreme Court almost the status of God?
no, sir, this is not the status of God according to me. Sir, it is just varied powers where it can do complete justice and to compensate people.
But when I'm not seeking that compensation, why are you giving me the compensation?
Sir, on the cause of natural justice.
Natural justice is not here. What is natural justice anyway?
Sir, justice which has the essence of fairness, equality, and reasonability.
Yeah, but when I don't pray for it, I don't seek that remedy. Why is the court giving me that remedy? If it was, I would have sought that remedy. Give me an alternative piece of, in the alternate, give me an alternative piece of land. That should have been the prayer. Can you make a prayer to the Supreme Court that this is what I want, and the alternate, if you don't give me this, give me this? Can you do that kind of an application before the Supreme Court? I'm not aware. I'm asking you.
No, sir.
No, you have to seek a specific remedy. You can't seek an alternative remedy.
Yes, sir.
I don't know. Maybe a legal panelist can just chip in again. Viren?
Yeah.
Can I make a prayer in the alternate? I would like this.
Yes, can. But you have to take the leave of the court.
Yeah. So when I file my petition, can I mention it that way?
When you are filing your petition, then you file the complete petition. But during the course of hearing, you can ask to leave, the leave of the court. If court will allow, then you can alter.
But even in the petition stage, can I ask an alternative remedy?
Yes. There's no bar. Yes, yes, no bar. Yes, sorry. Yes, ma'am.
Yeah. Mayank,
Yes, sir.
there seems to be no bar in seeking an alternative remedy, but I don't seek the alternative remedy, yet I get the alternative remedy. That seems a bit strange. No?
Yes, sir. But as far as I know, this can be only to uh, equate the other party.
Compromise. You're saying compromise, not equate. Compromise. So Supreme
Yes,
Court
sir.
gets the power to compromise solution.
Rajgopal, it's like the protective assessments we make.
So Mayank, do you think the Supreme Court should have this power to find a compromise solution? It is supposed to do justice and not seek a compromise solution. That should be left to politics and to society.
Sir, Supreme Court does complete justice under Article 142. It
I
is an
agree,
aspect
but
of justice.
complete justice, does it mean compromise? ये तो पंचायत का काम है ना, कॉम्प्रोमाइज करना, बिठाकर चलो यार ठीक है, थोड़ा तुम कर लो, थोड़ा तुम कर लो. Any other court in the world which has this power?
Sir, I can't say.
Okay, right. Thanks. One more question I have. When a judge recuses from a bench, do they have to give a reason? Yeah, Mayank?
Sir, I don't know. Sir, I cannot say.
No, you would have read in the newspaper so many times this judge recuses himself from a particular case. Do they give a reason why they should recuse? Are they supposed to give a reason?
Sir, I'm not very clear on the point, but I think the reason should be given.
Okay, but you're not sure कि reason दिया जाता है या नहीं दिया जाता है?
Yes, sir. I'm not sure.
Okay. So tell me about how does the law impact medical profession?
Sir, sir, laws are made for the welfare of the society, and medical profession is also comes within the society. So some provisions have been made. Some provisions are there which protect the doctor if he, in good faith, does perform some acts and all, and the patient, when patient dies or there is some injury to him, then he is protected if he has done that act in good faith.
Which are these provisions?
Sir, section 87, 88 of the Indian Penal Code.
What does it say?
Sir, it says that it generally talks about general exceptions. When any person, sir, can I explain through illustration?
Yeah.
Sir, suppose there is a person lying on a road. A person passes from there, and he is a doctor. The person who was fallen was unconscious. He took him to the hospital, and in good faith, to make him recover, he did surgery. Outcome of which was that the person died. So the doctor would not be liable because he performed the surgery in good faith for the benefit of that person. Another, we can say, act of communication made in good faith. Communication made in good faith under section 93. Whenever a doctor communicates something in good faith to a person, then if the result or the outcome turns out to be something different or it harms the other person, then the doctor is protected because the communication was made in good faith.
Well, let's say take this example a little bit further. A person is allergic to a particular chemical, to a particular medicine, and the doctor doesn't ask him that question but administers the medicine in good faith. Would he be guilty? Would he be charged, or would he be let go? Because he did it in good faith. That is the best medicine available at that point in time. But then he did miss out asking the person whether the person is allergic.
Sir, as per Section 52 of the Evidence Indian Penal Code, good faith means acts done with due care and caution. So I think this act was not done in good faith. He should have exercised all the proper remedies. He should have asked the person whether he is allergic. He should have conducted the test, and then if it would have turned out that he was dead, then he is not.
Okay. The same
This is a
situation,
case of
suppose he had only 5 minutes to decide and administer the medicine. Would the situation change?
yes, sir. The situation would change because ultimately the person was going to die, and he did that in good faith. This
Okay,
will be
so
covered that he did
so the
in good faith because
good faith would depend on the time available. It could vary in the same situation. It could be different.
sir, I think it depends on the circumstances.
Good. Good. Okay. That's all from me, Viren. Thanks.
Thank you,
Archana,
sir.
Archana,
Yes. Yeah. Hello, Mayank.
Good evening, ma'am.
Okay, so I would start with what is the status of the three acts which are which are under amendment. What is the amendment? Why it is being made, and what is its status?
Sir, ma'am, the amendment is the Indian Penal Code and the Criminal Procedure Code and the Indian Evidence Act. They all have been tabled on the Lok Sabha. They have been introduced. The current status is that they have been introduced under the Lok Sabha and sent to the committee for its examination. A committee name I cannot recall. I think it is standing committee in Lok Sabha to which it is sent for examination. And need was to ratify certain issues like delay in delivery justice system. Because, for example, I can give example, ma'am, like investigation and charge sheet has to be filed within 90 days and 60 days respectively. So it has to be done in time bound manner, which will help to cut down the time of the cases.
When does it start with the changing of its names, and what are the new names?
Okay, ma'am. The Indian Penal Code will be called as Bharatiya Nyaya Sanhita, and Criminal Procedure Code will be called as Bharatiya Nagarik Suraksha Sanhita, and the Indian Evidence Act will be called as Bharatiya Sakshi Adhiniyam.
Okay, and just by the way, I think it is parliament. It is the standing committee in Rajya Sabha, perhaps. I'm not sure of it. And do you know who is heading it?
Please, I would request you to please repeat the question.
Who is heading the standing committee of Home Affairs?
Ma'am, I'm not aware.
Okay, just check on that. It's a Rajya Sabha BJP MP called Bijlal. And
Okay,
what
sure,
was the
ma'am.
reason? I'm not asking for the different clauses which are being amended, but why these three went for the amendment? The main overarching reason, what is it?
Because the earlier laws were made, the IPC and the Evidence Act were made by the Britishers, and this is made by our constitution, our parliament. This is
So,
made by us.
so
So those laws show that we are still under the control of the Britishers. We are governed by the laws made by the Britishers, and this will give us an special autonomy. Like we are governed by the laws made by our people, our parliamentarians.
okay, so one of the main reasons given by the Home Minister was that because it was the Britishers and the laws were made for Indians, so they were more bent towards punishment and not towards justice. So that rationalization is being done, that it should now be for the people and not to punish them.
Okay.
Looking for. Okay, what are your views on the age of consent in POCSO Act? What is the debate there? You are aware of
Sir,
the
ma'am, I'm not aware of the POXO Act. Recent debate going about the POXO Act, I'm not aware.
you are aware about the POXO Act.
Yes, ma'am, I'm aware about the POXO Act.
So when did it come?
Ma'am, Prevention of Children from Sexual Offences Act, it was in 2012, I think, 2012 or 13, I think.
Okay, and what is the age of consent there?
Ma'am, according to me, it is 16 years as far as I can recall.
No, so just brush up your knowledge about POXO Act. It's a very important thing, and the debate going on is also important.
Okay, ma'am.
So,
Right.
according to you, what is the biggest landmark judgment that has been made in Supreme Court of India, and how it has impacted the country? According to you,
Ma'am, according to me, the biggest landmark judgment in the Supreme Court of India has been the Keshav Nanda Bharti versus the Keshav Nanda Bharti case, because
just a minute, I'll stop you there. Besides this one,
besides this one, ma'am, besides this one, I would say it was Menka Gandhi case, which has a very vast impact on the society,
what's that?
because after the passing of the Menka Gandhi judgment, Article 21, which is procedure established by law, it has to be include. It has to include the terms of justice, equity, and fairness also. That is why it has impacted the society as far.
Sorry, by what you have said, I'm a layman. I'm not clear. What was the judgment about?
Ma'am, the judgment was about whether Article 21 should follow the strict principles of the law. No one, Article 21 says no one shall be, no person shall be denied life to right,
What was the issue?
denied.
What was the issue?
Ma'am, the issue was, I think she was not allowed to go beyond the territorial limit of India, which was her right to move abroad. So it was under right to life and to right to live with dignity.
And when was
So,
that?
yes, ma'am.
When was that passed? That judgment?
When the 80 and 1979, I think.
So, did it apply to when Mr. Narendra Modi was not allowed to go to US or Arvind Kejriwal was not allowed to go to Mauritius? Does the same law, same judgment apply? Are you aware that these people were stopped from going to these places?
No, ma'am.
Okay. Okay. Now, just about the current affairs, tell me something about the controversy about NHAI that is going on due to the CAG report.
And NHAI.
NHAI.
Ma'am, I'm not aware. I'm reading current affairs, but I have not read this topic.
You know what NHAI is, right?
Yes, ma'am. I know what is NHAI. It is National Highways Authority of India.
Do you know about the orders that are some recent orders about the ED appointment? You have to really brush up your current affairs, Mayank. Okay. Most urgent judiciary reform that is required, according to you. Most urgent. One.
Most urgent judiciary reform, ma'am. Ma'am, there should be a higher number of judicial officers in the country, so the delay could be cut down in delivery justice system.
And if we start now, how long will it take to do that? What is the shortage? Can you give me some numbers?
Ma'am, cases will be distributed and it will be done in very active manner.
So can you
I
give
cannot
me some,
say.
what is the requirement? What is the shortage? Because otherwise it's a vague statement.
Ma'am, there are so many cases pending before the courts, and
How many?
the over lakhs of cases are pending before the courts.
So 2 lakhs or 12 lakhs, 25 lakhs?
I cannot say the exact idea. I don't have the exact numbers.
And the vacancies?
Vacancies are less. Um,
Okay, so
I
you're from
don't have the.
UP, right?
Yes, ma'am.
You're from UP.
Yes, ma'am. I'm from Uttar Pradesh.
So, what is your view on the if you are a judge and a case comes to you where somebody's house has been mowed down by the bulldozers? So, what all facts and evidence would you see?
Ma'am, if the house was made according to the development plan or the master plan or the zonal development plan of the city, then it would be uh, illegal to demolish the building.
It
And
has
it was,
it has been demolished already.
then I would see,
Order,
yes, ma'am.
what kind of order would you pass based on what facts? So the petitioner has come to the court saying that my house has been demolished wrongly. What remedy would you give? क्या 142 use होगा क्या इसमें? To give an alternate place like the earlier question.
Ma'am, 142 cannot be given by a judicial magistrate or court because it is an exclusive power of the Supreme Court.
Okay, so what would the lower court do?
And to check into the legality of the order which, according to which the building was demolished, and some fault is there, then punish the guilty.
Okay, ठीक है. Thank you, ma'am.
Thank you so much, ma'am.
Sorry. Sorry.
सर जी प्रणाम सर. How are you, Mayank?
Good evening, sir. Sir, I'm good.
So, what is the meaning of your name?
Sir, can I proceed in Hindi?
Absolutely.
सर मयंक मतलब सर चांद होता है.
Okay, that's very well, and it has been in news quite a lot of late, isn't it? Why do you think
Yes.
India chose to soft land that particular vehicle on the southern pole, near the southern pole? Have you read about it?
Yes, sir, I have read about it. Sir, southern pole, no country has yet reached the southern pole of the moon, and it is unseen part of the moon, which cannot be seen. So it was difficult to land on the south pole. The reason for choosing south pole was the mineral composition, to check the mineral composition of the land there.
Right, you're almost there. Because that part is not illuminated very well. It's not illuminated by sun as good as other parts. There are craters which almost always keep in the shadow, and that is why volatile compounds may also be found there. Otherwise, sun rays will evaporate. That's besides the point. So, if a crime is committed by an Indian on the moon, IPC would still apply.
Sir, IPC applies to territorial acts, extraterritorial acts, a person done on extra territory. So it will apply on him, and he will be punished and prosecuted wherever he will be found in India.
Fine. Okay. Since you have mentioned Indian Evidence Act as one of the favorites, so what is the essential difference between a judicial proceeding and a quasi-judicial proceeding?
judicial proceeding is always done before a court, and quasi-judicial proceeding can be done before a tribunal also.
Very well, very well. Why it can be done like that? Why judicial proceeding always requires a court? That is the essence. I want to hear the essence. And it has to do so, as I indicated faintly, it has to do with the process of evidence.
Sir, judicial proceeding itself means the proceeding before a court.
That's absolutely right. Absolutely right. Why quasi-judicial proceedings are allowed to be held even at other places by other authorities, but not judicial proceedings? Does it have anything to do with the applicability of Indian Evidence Act in its strictest sense? Or let me rephrase. Does Indian Evidence Act apply equally with equal rigor and force to judicial and quasi-judicial proceedings?
No, sir. According to Section 1, Indian Evidence Act applies only to judicial proceeding in or before any court.
Yes, that's the essence. Okay, I'm just trying to engage you in the conversation. You also mentioned 498A as perhaps the topic of dissertation or something.
Yes,
You
sir.
mentioned it. Okay, okay. So what is the status of 498A for live-in relationships? Is it applicable?
Yes, sir. It is applicable according to Supreme Court judgments. It has made Section 498 is applicable to the marriage to relationships which are in the nature of live-in relationships.
All right.
So, if any cruelty is done by any spouse, any partner in live-in relationship, then he or she can approach the court.
And would that also be applicable to this thing, the same-sex marriages? Just a minute. Will it be applicable to same-sex marriages also?
Sir, according to me, it will not, because it applies to husband and relatives of husband. And in same-sex marriage, who is the husband or not, it has been not made clarified by the either by the parliament or by the court.
Absolutely right. Yeah. The other way of saying is that it protects women, specifically women. It protects the wife, isn't it? The protection
Yes,
is
sir.
available for wife. So do you believe that there is a need of, before same-sex marriages are legalized, there is also a concomitant necessity that the entire legal ecosystem be also evolved towards that particular end, isn't it?
Yes, sir.
That's very right. Okay. Have you heard about interpretation of statutes?
Yes, sir. I have heard about the interpretation of statute.
Interpretation of a statute. You must have studied as a module, I think. Yes.
Yes.
Why do we need interpretation, man? Something is already
Sir,
written. You read it and apply it. Why do we need interpretation?
Sir, sometimes the words are ambiguous or not clear. Then the courts read down what was the essence of the law, what it sought to be achieved, and what is the outcome. So interpretation has to be done in case of ambiguity, in case of unreasonableness.
And you must have also heard about these three kinds of principal rules. The literal rule, the golden rule or reasonable rule, and the purposive or mischief rule, isn't it?
Yes,
Why
sir.
would somebody call it golden? What is so golden about it, about that rule? Before that, do you know golden rule? What is the
Sir,
golden rule?
Sir, I have heard and I have studied also. I have read it. I have studied also, but currently I cannot recall the golden rule.
You must do this. Okay, these are very basics of, statutory interpretation. You must brush up. That's very necessary. Okay,
Sir,
just these
I'll
three
read
rules.
it.
At least be comfortable with it. Yes, you do.
Sure, sir, I will
Okay.
read it.
This international law, is it actually a law? Do you really believe it?
Sir, according to Austin, international law is not a law but a
I mean, does it have all the ingredients of law?
Sir, it does not have ingredients of law because it is not backed by sanctions. It does not have any punishment for its infringement. So according to me, it is not pure law. It is
All right.
just a morality.
ठीक है. It has the effect of law so long as the parties honor it, isn't it?
Parties honor it, otherwise not.
All right. Have you heard about these terms, insurgency and belligerency?
Sir, insurgency I have heard, and the other word I have not.
All right. All right. Are you there, man? I lost you.
Yes, sir.
Video.
Yes,
Okay. Okay.
sir, I'm here.
Okay. Okay. I'll give you a situation. Suppose you must have been thorough. I believe that every one of us, since our childhood, we are very well aware about Ramayana, aren't we? At least the major events. So, if IPC was to be applicable on Sri Lanka, what would be the charges against Vibhishana?
Shaurya, can you just repeat that question?
Sir, the question was this, that if IPC were to be applicable on Sri Lanka at that time, what provisions of IPC would be applicable to Vibhishana from the side of Sri Lanka?
I must.
Sir,
I'll talk to you later, Shaurya. Brilliant.
Sir.
Sir, waging war against the government or the state.
Was Vibhishana still bound to be loyal to Sri Lanka once he was ousted from the country? Do I recollect it correctly, Mayank, that he was ousted? The king ousted him, or say the government or the state ousted him completely from the country. Still, he was bound to be loyal to the government?
No, sir.
Okay, something to think about, isn't it?
Yes, sir. But I have not thought about this question ever. So first time I'm hearing so.
Of course. So just think about it. Okay.
Sir, your audio.
Which was about this thing. Is it not the case that the Honorable Supreme Court are now assuming the powers of almost a god? So I'll just take permission to continue from there. What is your view? Is it when judiciary is called a temple of justice, is it blasphemous for the Supreme Court to work as God, or is it acceptable? You said no, it is not like that, and Supreme Court is not behaving like a God. I am going one step further and asking you, confronting you, since judiciary is considered and deemed as a temple of democracy, what's wrong if Supreme Court acts like a god of that temple?
Sir, according to me, Supreme Court is the temple of justice, but the law should be followed in the country according to the rules written by the Constitution. So
can we say that there is only one God for this country, and that is the Constitution?
Yes, sir. That was I was trying to say that Constitution, according to me, is the God, and judiciary is the protector of the Constitution and final interpreter of the Constitution.
All right. Where would you rate? See, you believe that the judges should be very honest. They have to be honest. Integrity is a very important ingredient in the functioning of a judge, in the character of a judge, because that is not only, necessary to be there, but it is something which is non-negotiable, isn't it? If you start naming the qualities of a judge, integrity should come at number one, because they cannot be compromised. So be fair to yourself and be fair to the question and the occasion. Rate yourself in terms of integrity at a scale of 1 to 10. Where do you rate yourself right now at this stage?
Sir, at this stage, I'll rate myself full 10 on 10 because, according to me, justice is never to be denied or destroyed. Or if one plays with justice, then this is the biggest wrong he
I'm
can.
asking how do you rate yourself in terms of integrity? How honest you rate yourself? If you say 10 out of 10, how do you say that? On what objective basis you say that?
Sir, because according to me, I will not do anything wrong with any people because currently also I'm not doing anything wrong with anyone. Uh,
That
so
is being
I
nice. Not doing anything wrong is being nice. That is not being honest. I asked you about honesty. That is being righteousness, isn't it? You are righteous because you'll not do anything wrong to anybody. That's right. That's a different virtue altogether. I'm asking you, how do you rate yourself on the scale of honesty?
sir, I'm honest and I'm 100% honest. I believe in honesty because
Do you
honesty is the
drive?
best
Do you
policy.
drive or ride a bike?
Yes, sir.
Would you stop at 3 a.m. in the morning at a red light, even if there is no necessity?
Yes, sir.
Okay, I'll take your word for it, and I look forward to a brilliant and an honest judge in you in your career. All the best from my side. I'll stop here.
Thank you so much, sir.
Yeah, ma'am.
Hey, good evening, sir. I'm
Ma'am,
good, sir.
ma'am, there is a lot issues on the collegium system. Why there is the
Yes,
issue in the collegium system?
sir. There is a issue in the collegium system because uh, one side says that judges are the protectors of the constitution. Judges are the sole protector of the constitution. Judiciary is the temple of justice, and if collegium system prevails, then the judges are in the high court and the supreme court are appointed by the senior most judges, which a 4 member collegium which is constituted to appoint the judges.
I have not
So,
asked about the procedure of the collegium system. Why there is issues on the collegium system?
sir,
What is the
the
issue?
issue, sir, the issue is that people say that it is not fair system because when judges appoint judges, then it will be like they will appoint their near and dear ones. So this is the main issue which people say.
What's your opinion?
Sir, according to me, and this is not the correct view, those who are qualified are only appointed and elevated to the posts of High Court and Supreme Court. It's all about qualification and
Who will decide this?
sir, the experience they hold and the seniority which they have.
Myself, you, Shaur, Rajgopal, Archana, all are in the fray. All have the qualification to become judge. Who will decide it?
Sir, a collegium will be framed and it will be decided by the qualification. Sir, already in the bar, currently there is a issue, Bar Council of India versus, I think, about the appointment of judges. Supreme Court has said that only those people will, it has made some criteria.
Given the one line answer, present collegium system is right or wrong?
Sir, according to me, it is right.
Right. It means you don't want the interference in the judiciary appointment. It is being alleged that there are certain caucus is there, certain lobby is there, certain coterie is there. They are appointing their own people. It is true or false?
Sir, according to me, it is not true.
You are saying that present system. You are saying present system should go on. Collegium system should work.
Yes, collegium system is good, sir. According to me, it should prevail.
This system has a transparency.
Yes, sir. The system has transparency.
You just see again the facts there. Only the main objection is there. This system does not have the transparency. The people who is appointed as a judge, anybody knows what is the ground, what is criteria to be appointed. Have you know how any judge has been appointed? Have you seen any idea? Is it under the RTI? Is it in the public domain? Judges should disclose their property or not? Are they disclosing their property?
Sir, I don't have the idea.
Can you explain me the secularism in the constitution?
Yes, sir.
Explain me.
Sir, secularism means the state has no religion of its own. It considers all the religions as equal.
Listen question carefully. Explain me the secularism in the constitution.
Sir, I request you to please repeat the question.
Explain me the secularism in the constitution.
Secularism in the constitution. Yes, sir. The constitution is secular because it applies to all persons belonging to any religion.
How you can say the constitution is secular?
Sir, I can give example like Article 14, Article 21. This belongs to all persons. Article 19 belongs to all citizens, whether they are of any caste, color, creed, sex, place of birth.
Anything else?
Article
Anything else?
Yes, sir. Article 15 and 16 also talks about appointment and also
Can
for admission also.
Can you compare Article 142 and 144 of Constitution? Do you know what's Article 144 of Constitution?
Sir, 144, I don't know.
You know 142?
Yes, sir, 142, I know.
142 and 144 combined, they are complete justice. You know this?
Sir, 142 I know, 144 I have not.
Do you have any idea about the Manipur issue?
Yes, sir.
Tell me.
I have read it.
Tell me.
Sir, the state of Manipur is divided into plain region and which is called the valley, and the hills. In the hilly areas, Kuki and Naga tribes live, and in the valley area, the Methi tribes live. The Methi tribe have a population of around 54 or 55%, but they live in the 10% area which is in the valley. Whereas
what is the dispute? What is the dispute?
Sir, the dispute is that since 2013 and 14, the Methi tribes have been demanding their ST status so that they can get reservation in jobs, and also they can buy lands in the hilly areas because 10% area in which they live.
Okay. Fundamental duty has any importance in the Constitution, in the life? Are you just a waste of wordings there?
No, sir. According to me, a fundamental duty has effect because fundamental duties every citizen has to do to develop scientific temper, we can say, for the current example going on.
Okay, if the citizen is not doing, what will do?
Sir, there is no sanction behind it, fundamental duties.
Then it is useless?
No, sir, it is not useless because we have to be motivated enough to follow these rules. Those are basic rules.
You can motivate it, but I don't want to follow fundamental duty. What will do?
Sir, certain fundamental duties which, if not followed, then there is punishment in different acts, in different laws. Like if one does not respect the national anthem, national ideals, or national symbols, then there is punishment under different laws. But all or
I'm not.
all are not binding.
I'm not disrespecting. I'm I'm not doing any.
Sir, it does not have the force of any sanction. One cannot pressurize the other to follow it.
Fundamental duty can be used for interpretation of the Constitution.
Sir, as per me, as per my knowledge, I think fundamental duties cannot be used for interpretation of the Constitution.
Have you read the case of Mohan Kumar Singhania?
Pardon me, sir?
Mohan Kumar Singhania.
No, sir.
In that case, it has said that the fundamental duty can be used for interpretation of the Constitution. Have you read this?
No, sir, I'm not aware of the case. I'll read it.
Preamble is part of the Constitution, not part of the Constitution.
Yes, sir, preamble is the part of the Constitution.
What is significance using the secularism in the preamble of the Constitution?
Sir, secularism,
It was already in the Constitution. Why you are
it was,
using in the preamble? What difference it will make?
sir, it will not make any difference, but it will just have that we have these concepts, we have these values. It is just demarcation.
What is one quality you need in the judge? Tell me only one quality. One most important quality.
The judge should have patience.
Patience.
Yes, sir.
Anything else? A person has the patience, but person has does not have the integrity. Then
Sir, he should also have integrity.
if he has the integrity but does not have the patience,
Sir, likewise, there are many qualities a judge should have.
okay. Give me these two combination. A judge has the patience, not the integrity. A judge has the integrity, not the patience. You have to choose one. To whom will choose?
Sir, if I have to choose between these two, then both are necessary, both are required. But if it is insisted to choose, then I'll choose like integrity should be there.
But you said right now patience is most important. You're changing your stand.
Sorry, sir.
In Allahabad, there is a lot dowry is being given to the PCS officers. You will take dowry.
No, sir.
Pakka.
Yes, sir.
Why will not take dowry? The person has a lot of money. He wants to give. What's the problem? He wants to give voluntarily. You are not asking. He's giving. He said, I have the plot. It is the tradition in Allahabad. The people are giving dowry, the plots, the cars. Person has a lot of money. He wanted to give you. What will you say?
Sir, it is against the integrity. It is against the principles. So
Why?
I will not accept.
He's giving to his daughter. How you can stop him?
Sir, to his daughter he can give, but I'll not accept. If he tries to give it to me, then I will not accept.
Everywhere in the marriage, you must be aware of this. The plot, the land, the house is being in the name of the daughter only. Is it dowry or not a dowry?
Sir, according to exceptions, there are certain exceptions of dowry. The special gifts or presents which are given without any demand, and then those are exempted from the definition of dowry.
You will choose a person who has a lot of money. Without demanding, you are getting dowry. It is not a dowry. You have the interest to take money. You have chosen a person. You got the 4 or 5 proposals. One proposal has a lot of money. The person. There's a rumor in Allahabad he is giving a lot of offer to everyone. It's a practical aspect of the life. You must have heard this. You will manipulate in such a way that you choose the girl whose father has a lot of money. It is not a dowry.
Sir, I'll not go this way round.
Thanks a lot. Thanks a lot. Sure.
Thank you, sir.
Rajpal, आप
Thank you, sir.
सर राज श्योर आप ले लो पता आ जाएगा राज श्योर
सर मयंक 3-4 अच्छी चीजें पहले आपके बारे में आई वुड लाइक टू टेल योर I'll say कि the pace with which you form sentences and speak is very good. I am satisfied. Personally, I am contented with the pace with which you speak, number one. Number two, you have a sense of proportion. You stop when the answer is sufficiently answered. That is a very good thing. Okay, that is the second good thing. But sometimes it felt abrupt. So only a couple of times it felt abrupt that you stopped without sufficiently answering. So keep that in mind. Ask yourself, have I properly satisfied? And the best way is to look at the face of the person who posed that question to you. That is a non-verbal communication that you can very well rely upon. You can very well trust on the expression of the face. If they are still not satisfied, you will come to know. Then continue with one more sentence. That's all. Do not try, you will not, but it is still advised, do not try to stretch any answer more than 3 sentences. 3 to 4 sentences are usually enough for an interview which overall lasts 15 minutes. Okay? So that is one. Then some suggestions. Number one, never ever try to defend judiciary or Supreme Court beyond point. Okay? When you find yourself trapped or cornered on a particular point, and the best way out is to accept that your understanding, your studies are still not that deep or that mature to sufficiently take a stand which can be objective stand. For being objective, you need to be informed, well informed, na? And well meditated. So when एक बार बोला, 2 बार बोला और फिर से अगर हमला हो जाए कि नहीं ऐसे कैसे बोल रहे हैं, सुप्रीम कोर्ट तो भगवान बन रहा है, इस तरह की जैसे भी चीजें, this is just an illustration. At that point of time, as a very sincere student and scholar of law, you must admit that, sir, this is a very important facet, and I think my understanding needs to be enhanced and enriched for being able to sufficiently answer this question objectively. No shame in it. ज्यादा उसको खींचना नहीं तो आप उसी मोड में चले जाएंगे, डिफेंड करने लगेंगे अननेसेसरली. ठीक है?
ओके सर.
उसके बाद जो है, ठीक है, इस पर तो अभी आई एम somehow inclined, personally not very convinced to ask you to go and start studying something, but it never harms to just brush up your syllabus. Brush up your syllabus like that, just like that. Every line of the syllabus you go through, and if you find you are intelligent enough to delineate that this is the aspect कि इसको मिस करके नहीं जा सकते, ये तो ब्लंडर हो जाएगा. I think you are intelligent enough to do that. Okay. You also answered about landing of that soft landing on moon and all, which was not supposed to be your core subject, but I appreciate it. You did very well. And then later on, you were answering. You're answering sufficiently. I think that as a candidate, you are good. But what I would still suggest that your pace is okay, but your takeoff is more than required, prompt more than required. Okay, take a moment. Take a moment before you take off. Take a moment. That is all. 2-3 seconds. That will be very good. Then I believe that you yourself can answer it better if you think properly for 3-4 seconds and then start answering. I still hold the opinion, subject to correction by my respected senior, कि आप 142 आर्टिकल 142 वाला जो आंसर था कि मस्जिद के लिए जमीन क्यों दे दी, अगर आप थोड़ा अच्छे से कंपोज होकर सोचते तो आप ही दे पाते उसका आंसर. दैट्स माय गेस. स्कोप ऑफ, आप बार बार बोल तो रहे थे कंप्लीट जस्टिस, यू कुड हैव एलैबोरेटेड अपॉन इट दैट दिस इज द ओनली एक्सेप्शनल आर्टिकल 142 जहां पे कंप्लीट जस्टिस का मतलब ही यही है कि द कोर्ट में पास एनी ऑर्डर, एनी डिसीजन if it deems that ends of justice will meet by this order. और उसमें आपको टेक्निकल चीज लानी चाहिए. मेरी अंडरस्टैंडिंग तो बहुत लिमिटेड है, लेकिन जो थोड़ा बहुत पढ़ा उसके अनुसार मैं कह रहा हूँ कि उसमें टेक्निकल एस्पेक्ट ये था, इफ आई एम करेक्ट, कि जो मॉस्क थी दैट वाज नॉट अबैंडन्ड बाय द मुस्लिम ब्रदर्स एंड सिस्टर्स, दैट दे वर डिस्पोजेस्ड ऑफ द मॉस्क बाय नॉन सेक्युलर मीन्स. That was the point. अगर अबेंडेंट चीज होती तो कॉम्पेंसेट करने का कोई क्वेश्चन ही नहीं था. दे वर डिस्पोजेस्ड, isn't it? उनसे हटा दिया गया, जैसे क्रिएट करके उनको हटा दिया गया था पोजीशन से. कुछ ऐसा रीजनिंग था ऑनरेबल कोर्ट का उस समय का, मुझे जो याद आ रहा है. आप इसे पढ़ लीजिएगा. इट्स अ वेरी गुड क्वेश्चन टू टेस्ट. तो सर ने जो पूछा है कुछ सोच समझ के ही पूछा है, तो आप इस पर एक अंडरस्टैंडिंग डेवलप कर लीजिएगा कि आर्टिकल 142 का क्या स्कोप है. आई मीन आप अच्छा बोल रहे हैं, इसलिए मुझे कहने का मन होता है कि these things, these logical analysis, these things should come out through you like poetry, isn't it? As if you have imbibed it and you understand it. तो फिर 4 चांद लग जाएंगे जिसे कहता है, तो बहुत अच्छा हो जाएगा. आपके आंसर्स बहुत अच्छे होने लगेंगे. ऑलरेडी दे आर गुड, बट दैट इज माय एडवाइस. और मैं समझता हूं कि आप एक बार बार बोल रहे थे डिलीवरी जस्टिस. इट इज द अदर वे अराउंड. जस्टिस डिलीवरी मैकेनिज्म है वो, डिलीवरी जस्टिस मैकेनिज्म नहीं है. Am I right, Mayank? You
Yes,
concur
sir.
with me. You
Yes, sir.
unknowingly, as a matter of slip of tongue, you were using this phrase again and again. It is justice delivery mechanism, not delivery justice mechanism. Okay, so correct that part. And I believe sometimes this no sir comes as an offensive bit actually. Sometimes if respected panelist is making a statement and you do not agree with it, or you want to clarify something, then you start with no sir, I think ऐसा होता है. Don't say no sir. उसी से शुरू कर दो. Sir, I think या I believe या it is my respectful opinion. इन phrases से शुरू करो. No sir बोलने का जरूरत क्या है? जैसे मैं यही पूछ रहा हूं, तो क्या आपका मानना है कि सुप्रीम कोर्ट भगवान बन रहा है? तो इसमें नो सर ना बोलो कि सर आई बिलीव दैट इज नॉट द केस. नो सर से शुरुआत मत करो. अननेसेसरी वो बड़ा अजीब सा लगता है कई बार. नो सर सुनने में ही मुझे लग रहा है आई डू नॉट हैव एनी थ्योरी टू सपोर्ट इट, नो साइकोलॉजिकल एनालिसिस. इट इज आउट ऑफ माय एक्सपीरियंस. ये जो मैंने एक्सपीरियंस किया आपको नो सर बोलते हो नहीं अच्छा लगा, सो व्हाई नॉट ड्रॉप इट. डोंट से नो सर, स्टार्ट विद सर. बाकी मुझे ठीक लगा. आप यू हैव एन पेक्यूलियर इनोसेंस इन योर कैरेक्टर एंड आई ट्रूली बिलीव व्हाट यू सेड. और आप जो बातें कह रहे हैं, बस इस चक्कर में किसी रटे रटाए आंसर के चक्कर में ओवर आइडियलिस्टिक आंसर मत दीजिएगा. दैट इज माय वर्ड ऑफ कॉशन एट द लास्ट पॉइंट. ओवर आइडियलिस्टिक आंसर नहीं देना है. आई अप्रिशिएटेड यू रेटेड योरसेल्फ 10 out of 10. नथिंग रॉन्ग विद इट, एब्सोल्युटली राइट. ठीक है, वो सब ठीक है. इंटीग्रिटी को छोड़ के बाकी किसी मैटर में अननेसेसरी का आइडियलिज्म मत दिखाइएगा. इंटीग्रिटी में जरूरत पड़ता है आइडियलिज्म का, होना ही चाहिए. ये एक फील्ड है जो नॉन नेगोशिएबल है. बाकी में बी वेरी प्रैक्टिकल, बी ओपन टू व्हाट पैनलिस्ट्स आर सेइंग, बी वेरी रिसेप्टिव टू देयर आइडियाज. और कहीं बहस होने लगे, कभी बहस मत करना. मैं याद रखना, कभी बहस मत करना. बहस होने लगे तो अपनी लिमिटेशन स्वीकार कर लो कि सर आई थिंक आई नीड मोर स्टडी टू बी एबल टू स्पीक टू योर काइंड सेल्फ, टू बी एबल टू डिलिबरेट अपॉन इट. साफ सीधे विड्रॉ कर लेना है 2-3 के बाद. जैसे सर ने एक बार बोला तो क्या आप अपना स्टैंड बदल रहे हैं, तो आपने बोला सॉरी सर. नहीं, इसमें सॉरी की कोई बात नहीं है. सर आई स्टैंड एजुकेटेड सर. यू से इट ना, आई एम सो थैंकफुल टू यू सर दैट आई स्टैंड एजुकेटेड. नो शेम इन इट. इसमें सॉरी क्या बोलना है. तो वो तो आपके फादर के उम्र के और एक्सपीरियंस के लोग हैं, तो अगर वो कुछ बता रहे हैं उससे आप थोड़ा सा मॉडिफाई भी करें, नथिंग रॉन्ग इन इट. देयर इज नो शेम इन इट. प्रिंसिपल्स के मैटर पे डोंट गिव इन. इंफॉर्मेशन और कॉन्सेप्ट अंडरस्टैंडिंग और 4 बात पता चल रही है तो यस एक्सेप्ट इट ग्रेसफुली. वो ज्यादा आपको नंबर देगा. ठीक है, ऑल द बेस्ट. यू विल डू वेरी वेल. यू विल डू वेरी वेल.
Thank you so much.
Archana.
So, reiterating what Shaurya just said, I would like to point out that you are not the advocate of judiciary. You should not be advocating judiciary. In your frank view, if something is wrong or something is not fully correct, frame it that way. So everything, it seems as if the judiciary system in India is perfectly correct at this point of time. It was what was coming out, which is not true. You also might be knowing it. So I don't think they must be looking for somebody who is compliant, who is saying yes to everything and all that. Okay. Secondly, on that question of integrity, again, when you said 10 on 10, that was good enough. But when he asked you a specific instance of riding a bike at 2 a.m. in the night, that was a moment you could have grabbed it. You should have said, sir, it has happened with me. And I was with friends and I stopped at the traffic light and they said, why are you stopping? But it is my principle. So I am actually an honest man with integrity. that could have been used. And again, the current affairs needs to be brushed up, especially in legal field. Whatever is happening, you have to be abreast of it. Right?
Okay, ma'am.
So that's it. Thank you.
Mayank,
All
Thank
the
you,
best.
ma'am. Thank you so
Mayank,
much, ma'am.
जितने अभी तक लोग आए सबसे अच्छा करंट अफेयर्स मैंने आपका ही पाया. योर करंट अफेयर्स गुड, योर जर्नलिज्म इज गुड, योर डिलीवरी इज गुड. One of the issue which you need to see the conceptual issue. When Shaurya said you will stop at the traffic light at 3 a.m., you took time to answer. You just see the recording of it. So you don't take time.
Yes, sir. Yes, sir. I remember.
Yes, I
Yeah.
forgot to mention that. इतना
Yeah.
टाइम लिया है मतलब कि आप सोच रहे हो कि मैं honest हूँ कि नहीं.
हाँ, convince नहीं हो आप. It will give a wrong impression for a second time. Second, when the issue as dowry is coming, you are confused. You can take this stand. I will not take the dowry. Whether in the name of the girl or in the name of me, what's wrong in it? Why you are confused? I'm trying to give a long rope to you, and you are always taking that rope. If you have taken the stand, no, I will not take. Nobody can say anywhere I will take the dowry. If he will take, then also. You try to understand this basic issue. In the interview board, who will say? But how you say it is important. Now you have diverted yourself, and your mind was, and you are communicating indirectly. यार मिल जाएगा तो ले लेंगे. You take the proper stand. यार मैं नहीं लूंगा. जैसे जो राज्यपाल का सवाल था कि उस पे कि कोर्ट के पास कोई आदमी गया अल्टरनेटिव वो प्ली ले सकता. कोर्ट हैज एक्स्ट्राऑर्डिनरी जुरिसडिक्शन. इसमें कोई लॉ लर्निंग जानने की जरूरत भी नहीं है. इंक्लूसिव की डिफिनेशन आपने गलत कर दी. ये नहीं उनसे गलत ना. These are the
Yes,
basic
sir.
issues. Yeah. Views on 142 पे आप काफी, अब आप 142 जानते थे, 144 नहीं जानते थे. Complete justice not complete without 142 and 144. I this teach to the aspirant of the civil services. If the question of the complete justice is coming, you must write 142 and 144 together. If you are not including the answers generating from the article 144, the complete justice answer is not proper.
Sir, I'll read it today itself.
पास्को एक्ट आपको नहीं आइडिया है. सो अगेन आप क्या है ना कि आपने अगर सारी रिकॉर्डिंग सुनी होती तो मोस्ट ऑफ द थिंग्स है आपने सुना नहीं. उसमें बिगेस्ट लैंडमार्क जजमेंट हम शुरू से बोल रहे हैं. आप एक जजमेंट तैयार करो. द मोमेंट अर्चना सेड कि टेल एनीथिंग एज केशव भारती, आप ब्लैंक हो गए. कॉन्ट्रोवर्सी एंड एनएचए आपको आना चाहिए था. कोलिजियम सिस्टम पे अगेन यू हैव फंबल्ड अ लॉट. एक व्यू पर होना चाहिए ना. जो राज्यपाल मस्जिद का सवाल कर रहे थे बड़ा आसान सा सवाल था. इट वाज फुल टॉस. आप में प्लस पॉइंट है लेकिन दीज थिंग्स आपको आप देखें. रेस्ट इज ओके. अब क्या है, इतना लेट स्टेज है, वी कैन नॉट से समथिंग मोर. आई वाज इंसिस्टेड अपॉन टू गिव द अर्ली इंटरव्यू बिकॉज़ you have not prepared at that time. But anyway, you have a lot positive point to say. Yes, Raj.
Yeah, Mayank.
Thank you, sir. Yes, sir. Good
Good,
evening, sir.
I like your confidence. But sometimes if you're not sure about something, then just give it up. Don't give a wrong answer. The only thing. And one more point I'd like to add is, faced with a new type of a question where you are unable to recollect or you're unable to frame your thoughts, it might be good to think of yourself as a judge. What would you do if this kind of a situation, and what would you do if you're a judge? So actually do a creative visualization and be a judge and then answer. If you're faced with a situation where you're not really getting the right thing in the first couple of seconds, just think of yourself as a judge and see what would a judge do and then give that answer. That's all. Otherwise, you're all good.
Thank you, sir.
मेरे ख्याल से ठीक है सब. बाकी अच्छा है. क्या थोड़ा सा कॉन्सेप्चुअल क्लैरिटी रखो, बाकी सब अच्छा है. यू हैव लॉट प्लस पॉइंट टू सेल थ्रू. आराम से जाओ, ज्यादा टेंशन मत लो. हम लोगों ने बहुत लंबा चलाया, बहुत लंबा इंटरव्यू चला. अगेन आपका इंटरव्यू हम लोग ऑलमोस्ट कहते हैं 1.5 घंटे के आसपास लिया. मेरे को ऐसा कोई बहुत स्ट्रक्चरल डिफेक्ट आप में नहीं दिख रहा है. जो चीज नहीं आती है वो नहीं आती है। ओनली थिंग कि जब कन्वर्सेशन आगे बढ़े उसको होल्ड करना सीखो और सवाल को साफ साफ सुनो। ऑल द क्वेश्चन में आस्क, उन क्वेश्चंस में आपने सवाल को इवन जिस सेकुलरिज्म कॉन्स्टिट्यूशन में कहा है, अब आप बताने लगे कॉन्स्टिट्यूशन इज ए सेकुलर, ये तो बहुत ही अलग आंसर हो गया ना। आप उसके प्रेम्बल में है, आर्टिकल 21 में है, 25 to 28 में है, ये आप कहते सिंपल से। ये सवाल क्या था, ये सवाल मैंने क्यों पूछा था कि कई सवालों का आंसर आप नहीं कर पा रहे थे, तो ये सवाल आसान हो जाएगा, ईज हो जाएगा, हमेशा ही होता है। बाकी आपने प्लस पॉइंट है, आपका जो फर्स्ट इंप्रेशन था बहुत अच्छा था, व्हेन यू अपीयर ऑन द स्क्रीन, बहुत अच्छा इंप्रेशन था आपका। उस इंप्रेशन को आप कर ले जाओगे, आपका हो जाएगा। आई थिंक सर, सर कुछ और है?
सर बस ये कह रहे थे कि मयंक ज्यादा तो मत भटकना बेटा। आज के जो रिस्पेक्टेड पैनलिस्ट ने जितने भी सवाल पूछे हैं तुम वही तैयार करके चले जाओ, बस अच्छे से वही तैयार करके चले जाओ। मेरा विश्वास है कि भगवान आपकी सहायता करेंगे।
थैंक यू सो
अगर
मच सर।
आपके पास समय है आप रिकॉर्डिंग सुन लो, जितनी रिकॉर्डिंग हुई है। आपके जो सवाल है 50% सवाल कहीं न कहीं किसी पूछे गए हैं। मैं बता रहा हूँ, इस रिकॉर्डिंग को, जितनी रिकॉर्डिंग हुई है 22 कैंडिडेट की, वो रिकॉर्डिंग कोई आदमी सुन ले, एक अच्छी खासी तैयारी इंटरव्यू हो जाएगी, अच्छी खासी। दूसरा, आपके पास मतलब आप बोल अच्छा लेते हो, पहले आप कैंडिडेट हो जिसने करंट अफेयर्स तैयार किया हुआ है, बाकी किसी ने करंट अफेयर पे काम नहीं किया है। तो आई थिंक गॉड इज काइंड, मेरे ख्याल से काम होना चाहिए। ओके, टेक केयर बेटा, बाय।
थैंक यू सो मच सर।
ओके सर,
थैंक यू सो मच
सर। हम लोग क्लास